Welcome back. This is Tara Hutchinson with Pittsburgh Family Law Services. In today's video, I'm going to talk about 3 points to keep in mind and to consider when you're deciding whether to take your family law case to trial or to a hearing, or whether to settle it and resolve it outside of court. Now, this is a point of contention that a lot of clients will have with attorneys. It's very common that clients will ask us, should we go to trial or should we settle? And often an attorney will either not give a direct answer, or they will say, you absolutely need to settle this, it cannot go to a hearing. Or the opposite, attorneys will sometimes say, you have to go to a hearing. And there isn't a lot of discussion between the lawyer and the client about why they're advising in that way. So for this video, I want to go over just 3 points that I am always thinking of when I'm advising a client, whether it makes sense to go to trial or to attempt to resolve the case outside of a hearing. Now, just right off the bat, I will say, for myself and for probably most family law attorneys, the vast majority of our cases do end up settling without needing a trial. There are some attorneys who, of course, focus their entire practice areas on working with people who really need to go to trial. Those are the families they really want to work with. So that's a little bit of a different situation. But in most cases, your lawyer is going to typically settle cases without taking it to a hearing. And many times, in the vast majority of circumstances, that is indeed the correct decision. But it doesn't always make sense to settle outside of court. Every case is going to have its own unique facts, its own unique circumstances. The other thing to keep in mind, and this is also where clients will get frustrated with their attorneys, because sometimes we will highly discourage a client from taking a particular case to a trial, and then ultimately say, okay, you're the client, if you want to go to trial, we'll go to trial. And clients will feel like there's a complete 180 there. Why is that? At the end of the day, you are the client. Even if I strongly believe that you should not go to trial, it is ultimately the client's decision. So if, after hearing all of the information and all of the advantages and disadvantages, the risks, the benefits, the client still says, I understand, I hear what you're saying, I need my day in court, I want it to go to a hearing, I really have to follow, and not just me, but every attorney has to follow the client's direction in that regard. And for me personally, if I do not believe that I can do that, my obligation is to withdraw, because it is ultimately the client's choice. But that being said, what are the things that I am always keeping in mind when I'm advising a client? So the first thing that I always want to know when we're talking about, do we settle or do we litigate, is, what does litigation actually get you? What is the purpose of litigating? So if you are really saying to me, if you were my client and you're really saying to me, I want to go to a trial, I want to go to a trial, my first question is going to be, why? What does that get you? What is the end goal here? Even if you don't succeed. The best example I can come up with is like, let's say you are a plaintiff in a protection for abuse or a PFA action, all right? And you tell me you don't want to withdraw your PFA, you don't want to try to reach an agreement outside of a hearing. You want to go to a hearing and see if the judge will grant a final PFA order. That makes a lot of sense to me, actually, because and often I may very well say, okay, because if we go to a hearing, and the judge agrees that this is abuse and you need a final PFA for your own protection, we will go to that hearing and the judge can enter that order. And if the judge disagrees that it doesn't warrant a final PFA order, then the judge will dismiss the PFA action, and you're really in no worse of a position than what you would have been if you had withdrawn that PFA petition prior to going into a hearing. So that's an example of, yeah, if you're concerned for your physical safety, it makes sense. It may very well make sense to go to a final PFA hearing, because even if you don't succeed, you're not in a worse position versus if you decide to just withdraw your petition because the other attorney is saying this would never result in a final PFA, and you withdraw it, and you withdraw your petition because you're intimidated by the whole process. Under circumstances like that, it may very well be worth going to a hearing. So first question is, what does litigation or a trial or a hearing, what is the end goal, and what does it get you? What are you looking to achieve? The second thing that I always keep in mind and I always consider is the likelihood of success if we do litigate your case. The reality is, not all matters are created equally, and not all positions have the same chance of success. So, for example, if you are a parent and there is no evidence, no indication that the other parent in a custody case has an untreated or uncontrolled drug or alcohol abuse condition, there are no safety concerns, or at least no evidence of safety concerns. If your position is, I want primary physical custody and I want the other parent to only have supervised visits, the likelihood of that succeeding in court is next to nothing unless something drastic happens, which by the time you're looking at a trial for custody issues, if something drastic like that had happened, everybody would be aware of it. So in that circumstance, I would really emphasize, it's not that you can't do it. You are allowed to request a custody trial, but your likelihood of succeeding is very, very low. And understanding that this is an investment both of your time, your emotional resources, and your financial resources. Is this something that you actually want to take to trial, or can we work out an agreement without needing to do that? And finally, that brings me to my last point, is the cost. That absolutely has to be a consideration before deciding to take a family law matter to trial. And you'll see this a lot in divorces. So when we're dividing up the marital estate, sometimes we get very, very close, but there is a disagreement on a relatively small amount of money. Say we're about $10,000 apart. For a disagreement about that amount, that you really need to think about whether litigation is worth the cost. And by the way, I am not saying that $10,000 is a small amount of money by any means, but if you have to spend $10,000 in attorney fees to get an extra $10,000 in equitable distribution, is that something that you really want to do? Are you in a position where you can do that? And sometimes the answer is yes, sometimes the answer is no. You know, at the end of the day, when we decide to go to trial, we do not know what the outcomes will be. We can guess the likelihood of success. We can talk about what our own experiences have been in similar matters and what's likely to happen. But at the end of the day, no attorney is truly able to predict with 100% certainty every single time. So every case is completely different. That's why it is, at the end of the day, the client's decision whether to go to trial or not. But these are just some of the points that I always ask my clients to consider when they are making that decision for themselves. There's obviously a lot more that goes into making that decision, and I could probably spend hours talking about all of them, but these are just a few examples. What I would say are the main points. So I hope that was helpful. It is very important to talk to a local family law attorney if you have questions about your specific situation, because although I am a lawyer, I am not your personal lawyer. So I do not know all the facts of your individual case. So that's why I say it's very important that you at least have a consultation with a local family law attorney to discuss your situation in depth. I hope that was helpful information. I hope it was helpful. I wish all of you the best of success in your family law matters, and I hope for a favorable and speedy resolution to everybody. Thank you all again for watching. Take care. Bye for now.